you cross 33 road, 48 and a half road, and this intersection.
I didn't do none of that. I didn't do none of that. Give me the max. I'm done. Give me the max. I don't care. Give me the max. I will prove to you this whole courtroom. Dean DeMambro didn't do this. And y'all know it. You're all lying. You're all in on it. Every one of you, Judge, you're full of crap. And you know it. You sat there and watched that man lie.
I would encourage the court to just
whatever. Fuck yous, eat shit. You're all pieces of shit.
We are here today for a sentencing in this case involving a conviction of 2 charges. The conviction stemmed from a jury trial that occurred back on August 26th of this year. Let me take a quick look to see if I had any notes or process corrections. All right. I did not notice any need for correction. I'll start with Mr. Harrison while we're waiting for Ms. Carey to catch up. Mr. Harrison, any amendments, corrections, or objections to make to the content of the pre-sentence investigation?
This right here is the quiet math of sentencing that most people miss. Pre-trial credit sounds simple, but it's razor precise. If a defendant is already locked up on a separate parole violation, that time doesn't automatically count toward the new case. Translation: even days behind bars can become legally invisible, and that can add months or years on the back end.
Why the pretrial credit only ran from February 20th.
Right, July 1st.
Excuse me. Thank you.
They're bringing up the physical file.
I see him coming. Maybe. Nope. Yep. Nope. Well, Mr. Harrison, I'm going to begin by allowing you allocution. Go ahead. You may begin. It depending upon if there's any challenges, which if neither you or I caught any, I would expect there to be one.
And we'll cross that bridge when if we come to it, Your Honor. The reason I hesitated when you asked me about were there any proposed changes is that frankly I wish there were, because it is difficult to look at a PSI where the guy has seemingly what I would describe as somewhat normal levels. I mean, his PRVs are 85, which is beyond the 75 max, but then you look down at the OB score and it's only 15 points. Unfortunately, the primary driver of his score in this situation is his prior record, which results in the guideline that's reflected on page 1 of the SIR 8-1. And it's hard for me to wrap my brain around the fact that that is the case. Then I look at his MDOC status, and it does indicate that his sentence was 2 to 10, so 24 months to 120 months in Lake County with a potential ERD of 218 and 27.
This is the defense waving a legal red flag. He's basically saying, Judge, the numbers look scary, but they're misleading. When prior record variables explode because of overlapping cases, guidelines can snowball fast. The ask here isn't mercy, it's proportionality. Same conduct, different counties. Should that really double the punishment? That's the question hanging in the air.
And that again presents an interesting conundrum to the court due to the increased guidelines. In this case, due to the conviction for a C-grade felony in Lake County, which gave him another 25 points on his PRVs and really threw a monkey wrench in the whole works. It's no secret, it was no secret, that this is a continuation of the Lake County case for which he stands convicted in Webster County. So in a manner of speaking, I guess what I'm asking the court to consider doing is undercutting the guidelines here based on those two, what I believe to be extenuating circumstances here. First and foremost, that the Lake County sentence arises out of the same transaction or occurrence as the case in Wexford County, mere geographical accident that he was subject to trial in 2 different locations for essentially the same act, if you will. I know I'm oversimplifying, and I don't want to inflame anybody about jurisdiction and all that kind of basic tenets of criminal jurisprudence, but it's important to me that I emphasize, at least for the record today, that I think this case presents a compelling reason to, and I'm trying to be careful in the way I say this because I don't want to make it too dramatic a point, to ignore the guidelines. Now, I don't want to load up the term ignore too much because I don't think that's really what we're doing. I just wanted to bring it to everyone's attention that ERD in 27, it's February 18th, as well as the other factors that I think call for that sort of solution by the court. Now, if we look on the second page,
And here's the emotional gut punch. Prosecutors know juries and judges react strongly to risk to a child, and with good reason. Speed, wrong side of the road, blind curves, infant in the car, that's not just reckless driving anymore. That's the kind of detail that pushes a sentence from within guidelines to make an example.
when you've reached a certain level on your prior record variables. For all of those reasons, Your Honor, I would encourage the court to craft a sentence that does not unduly extend his stay in prison on the Lake County case. Thank you.
Thank you. Mr. Nate Carnes, the Chief Assistant Prosecuting Attorney, has now joined us in replace Ms. Carey. It's his file. I know he was running a bit late due to an auto issue on the way to the office. Mr. Carnes, did you have any amendments, corrections, or objections to make to the content of the report?
No, Your Honor.
Allocution on behalf of the people, then, sir?
Yes, Your Honor. The thing that sticks out the most to me with this is that the defendant was traveling up to 85 miles an hour, driving on the wrong side of the road around blind curves while there was an infant in the car. That's very disturbing to the people. And I heard most of what Mr. Harrison said. Yes, the defendant has high guidelines because of his priors, and this isn't his first plea and elude. This is extremely dangerous behavior that the defendant was found guilty of. I would urge the court to issue a sentence towards the top of the guidelines here. I'd recommend a sentence of 90 months.
Thank you. Mr. DeMambro, you have the right to make a statement if you choose to do so. I do recognize that you pled not guilty and were convicted at a trial. Is there anything you wish to say at this time, sir?
Yeah, I'm quite confused, as I have been this whole time. And it's hard for me, Your Honor. I'm trying to take your position as well as everybody else's, and I understand that there was a verdict reached. And I'm trying to be respectful to everybody, because I understand the process and I understand what's happened, and everybody has a job to do. I totally understand that. But what bothers me, okay, if I were one of them jurors that made that decision that day, okay, I would want to know everything regarding the case. Okay, I would want to know everything. And if them jurors were aware of everything regarding this case, that verdict would not have been reached, because that officer is lying over and over, and I don't have to prove that. He's done it himself by his own testimony, and it was all hid.
This is allocution at its most raw and most dangerous. Defendants get one uninterrupted chance to speak, and it can humanize them or sink them. Denying guilt, accusing officers of lying, and challenging the court's legitimacy, That rarely lands the way defendants hope. Judges listen for accountability, not conspiracy, and the temperature in this courtroom just spiked.
If you look at my past, my record, I haven't done, when I've been in trouble, you know, yes, I've tried to get a good plea, but I've never taken it to this extreme. You know, this is, you know, Your Honor, I was offered a misdemeanor on this case, and I didn't take it. That should tell you my sincerity in what I'm trying to tell you. And I don't know what else to say. I just, if there's any way, like I said, I understand you all have a job to do, okay? But, you know, I'm already in my classes here. I'm already signed up for Vocational Village. I'm at a facility here that has several different vocational trades that they teach. But I'm signed up for the tree trimming job. That is the only one that guarantees you a job for when you're released, but it's in the Wayne County. But I don't care. I want away from that area anyway. So, but the point of it is, Your Honor, I'm in ASAT, which it's approximately 6 months, and then I go into the vocational trade sometime soon. My classes are all started, and you know, this is gonna throw a big wrench. I don't know. I feel like I'm asking too much, but then, you know, Your Honor, you've been doing it. You know that officer's lying. You can't tell me you don't. I mean, I don't know if you've watched his other testimony, but listen and read. I mean, you guys have all been doing this the guy is lying. It's not that he's a rookie, Your Honor. He is lying. It's not that he's just inexperienced. He's experienced in lying to you. And I mean, I feel like he's been, you know, because he had a whole different attitude in this courtroom than he did in Lake. In Lake, he thought it was funny. He laughed as he lied, smirked, you know, and it was like intentional. But up here, he tried to act more professional and more, you know, I feel because of the difference in the courtroom. I believe he, you know, I don't know. I can sit and, you know, come up with all the reasons, but I know personally that the man's not telling the truth. Okay, Your Honor, I don't know what else to say. I can't tell you, hey, I did this when it's not true. I didn't do it, you know, and I don't, and it's hard for me. And I mean, if I just want it to be over with, if there's any way that we can give me what I have and just be over with, I'll take it as, you know, I'm going to try, no matter what you do today, Your Honor, I'm going to try to learn from this so that I can change my life and stop being the person I was yesterday, the day before, and be a new me and get out and be successful, because I'm not a stupid person and I'm not what my PSI says. I am capable of better things than this. And, you know, it's embarrassing for me to be sitting here in front of you, even though the circumstances and everything, it's, you know, embarrassing. And it bothers me tremendously, because I know I was raised better than what what these PSI says, you know, I want to live, Your Honor. I've done, you know, I can't even tell you, over 15 years, somewhere in there, ever since I've been about 24, this has been my life, and I can't seem to shake it. Please have mercy on situation, and understand that I'm being sincere. I'm not up here trying to pull your chain. You're a very smart man. I can tell it, and I can tell you're very, very good at what you do. Just take everything into consideration, please, Your Honor. I already have, everything in here is set for your ERD, which is 2/20, I think, of 27. And everything's already started, Please take that into consideration. That's all I have to say.
All right. Thank you. Before the court this morning is a 42-year-old man who has had a long history with controlled substances for about 25, 26 years. He has mixed failures and successes at rehab over the last, in and out of rehab programs for the last 25 years. The defendant's prior criminal history is impressive in a negative way. It started out with some juvenile issues back in '96. Looks like he got probation. He was off for about a year before he picked up his first set of charges as an adult. But that one was dismissed. So then he made it a couple years, then he picked up another case. Now in case 22 of 31, back in 2001, the defendant absconded from probation in the midst of it, had probation violations, numerous violations, and numerous warrants. In fact, he only made it about 6 months between the date of sentence and the next case that he picked up back in 2001. In fact, he had multiple convictions. It's not merely that he had probation violations, but he had probation violations that resulted in convictions. He had about only within a couple more months did he pick up number 4 of 31. I'm sorry, that one. Oh, you know what? I'm sorry. That one was dismissed, so I disregard that. But he picked up number 5 of 31 while on probation. Number 6 of 31 while on probation. In fact, it was only 7 days after the one prior. It looks like he made it about 6 months before he picked up yet another violation of that same probation when he picked up 7 of 31. And then he did the same thing when he picked up 8 of 31, and that was all on probation. He made it a couple months before he picked up 9 of 31. And when I say a couple, I mean literally about 2 months and 1 week before he picked up the next one while on probation. Number 10 of 31 occurred while on probation. In fact, that occurred only 11 days after 9 of 31. He was doing terrible on probation. In fact, then he picked up 11 of 31. Actually, while on probation and while on bond for the other cases. 12 of 31 occurred 2 months after number 11, and he was still on probation. So, yeah, it's like the 9th case while he was on probation for number 2 of 31. Then it continues. 13 of 41. Looks like he had just been off of probation, but only for about a month. 5 months. 14 of 21 came only about a month after 13. Then he made it about 2 weeks before he picked up 15 of 31. Then a number 16, he was on bond, violated bond, picked up another case. Number 7 of 31, he was still on bond for number 15 of 31. So we're starting to see that he's violating bond. I don't know if he's ever completed probation successfully. But multiple probation violations. 18 of 31 occurred while on bond. 19 of 31 occurred while still on bond. It was only a month after 18 of 31. 20 of 31 occurred while he was on parole. Then it looks like he had a sentence. Looks like 2 months later after being sentenced. I don't know, this must have occurred All right, so he got 6 days, 16 days in jail. And then after he got off of that, he had another violation. 21 and 22 occurred while on parole. 23 occurred while on parole. Between 23 and 24, he did make it about 3 years, but sure enough, we're getting back to failing. This is a flee and elude. So I've got repeated flee and eludes, R&Os, failing to comply with bond, failing to comply with probation, failing to comply with parole. So for number 24 of 31, which had that flee and elude and R&O and reckless driving, he out of Osceola County, he got 14 months to 2 years. So a prison stint didn't help that. Number 25 of 31, sure enough, we got another reckless driving and a flee and elude. That occurred while on bond. Number 26 of 31, we have another R&O, and that's only about like 9 months after being off of probation or parole from the previous file. 27 of 31 occurred while on parole, and that one was resolved in April 12th, 2024. He made it 7 months before picking up this case in Lake County, not Osceola County, but Lake County and Wexford County, the ones that we're here for today. Now, before I talk, what's that?
28 is the Lake County convictions, not?
Yeah, it's
Okay.
Lake County. I
All
thought you
right.
said
I was
Osceola.
confused.
I thought
All
you said Osceola earlier, so I'm sorry. But
You may have, that
Yeah.
maybe why I got sidetracked.
then, while these cases were pending, what happened to 31 or 31? Did that get dismissed?
Yes, sir.
All right.
People did dismiss
All right, so I'll disregard that.
the next two files, 30 and 31.
Now, as to the officer, Officer Killingbeck, and this is conservation officer, not the trooper Killingbeck. It's one of the first times I'd ever seen him in the court, and he did a pretty good job providing testimony. But I'll say, no matter what, his testimony was supported by the person, the woman, he left in the car with the kid, and his ID was in the car. So his attempts to try to tell me today that the officer was lying, even if I consider the officer not telling the truth, which I don't, the girl was in the car with the child and his ID. And he tends to run away. He tends to abscond. He tends to flee and elude. He tends to resist arrest.
She's admitted it wasn't me.
Stop talking. Do not talk again. You had your opportunity.
Yes, sir.
Thank you. And we have 2 jury trials, which means 24 independent people who I cannot challenge and will not challenge have all found you guilty beyond a reasonable doubt. So there is no confusion for this court. You fled and eluded police officers, something that, by the way, you have a tendency to do.
Yeah.
You resisted arrest. You resisted arrest, which is something you have a tendency to do. You violated parole. Well, you violate parole almost all the time. You violate probation and bond in almost every single one of your convictions, which I think were approximately 25 convictions over the last 25 years. You're in and out of jail, on and off of probation, on and off of bond, on and off of parole, in and out of prison, constantly. And a jury conviction. So I don't think there's any part of your story that's true. And I can follow this route. Snookum Road down in Lake County. You take a left, start heading down toward Wexford County. You cross 33 Road, 48.5 Road, and this intersection.
I didn't do none of that. I didn't do none of that. Give me the max. I'm done. Give me the max. I don't care. Give me the max. I will prove to you this whole courtroom. Dean DeMambro didn't do this. And y'all know it. You're all lying. You're all in on it. Every one of you, Judge, you're full of crap. And you know it. You sat there and watched that man lie.
I would encourage the
Yeah.
court to